Hey everyone, Harry here to talk about the big, giant, ginormous, gargantuan decision by the Colorado Supreme Court ordering the Secretary of State of Colorado to take Trump's name off the primary ballot for president in Colorado. Man, where to begin? I guess here, this is a total constitutional curveball in a sense. But if you've been following the issue as it's first kind of bubbled up from different lawsuits, you could sort of see it coming, at least very plausible, after the decision by the trial court in Colorado, even though it went for Trump, because the trial court held that the important clause, Section 3 of the 14th Amendment, didn't apply to him because the president's not an officer. It had, and I wrote this at the time, it gave a higher court, the Colorado Supreme Court, everything it needed except just a legal conclusion that it could do on its own in order to disqualify him. So sure enough, by a 4-3 vote, so, the thinnest possible margin, the Colorado Supreme Court holds that he can't be on the ballot because the short way of trying to put it, he engaged in insurrection, having taken an oath of office, and therefore, by the plain terms of the provision, he's not qualified to be president, same as if he were 34 years old. They considered and rejected the notion that officer doesn't include the president. Basically, the argument there is, come on, would the Congress that passed that 14th Amendment meant really to have excluded the leading person in the rebellion, and the argument on the other side is a sort of plain textual one. It doesn't include president in the list, but anyway, they reject that. They basically agree or affirm, because that's what you do as a court of appeals. You don't exactly replicate, but say good enough for government work, that the Judge Wallace below had found under the facts after a week-long evidentiary hearing that Trump had engaged in, and that's a sort of required a First Amendment analysis, that it wasn't just advocacy and political speech, but it was really a kind of clear and present danger. And insurrection. And she had defined, Judge Wallace, insurrection in a fairly open-ended way. And the Colorado Supreme Court affirmed, saying, whatever it is, trying to overthrow or keep the government from certifying presidential votes, that's good enough for an insurrection. And so, there you go. Kind of looks like what you might have thought an opinion holding that he's out would look like. But now we come to the three dissents. So that's what they held. Next, let's talk about where we are and what happens next. So they stayed their ruling, their command to the Secretary of State until January 4th. Why January 4th? January 5th is the Secretary's last day to finalize the ballot. And so they want to give the U.S. Supreme Court as much time as they can to review the ruling. And will the Supreme Court take the case? Actually, let me make a general point two. We are in the phantom zone, twilight zone, terra incognita constitutionally. This is a really not just unusual and extraordinary, but kind of lacking in precedent and grounding for how even to go about deciding it area. So it's not just huge and extreme on the facts, but it's huge and extreme on the law. So, what happens next is really a pin the tail on the donkey guessing game. But they leave that time for the Supreme Court. Supreme Court plausibly could just, pass on it and leave the situation as it is in Colorado, and that's it. Very hard to see that. This seems to me to force some opinion from the U.S. Supreme Court, and we should look in very short order. The 4th is what, 15 days away? A little more than 2 weeks for the court to take it, order briefing, have an oral argument, and decide all by the 4th. Okay, so that's point 2. Point 3, what will the court do? Look, there's a chance that they could affirm, but it's a bit bizarre what they would be saying. They would just be saying Colorado committed no error of federal law. They decided that their state law covers it. They're the authority for who gets on the ballot, and that's they've made that judgment, and that we wash our hands of it. And then you would have a situation where he's on the ballot in 49 other states. He's not on the ballot in Colorado, though those other 49 states have been given a sort of green light. They haven't been ordered to take him off. It's very hard to see how the Supreme Court could do that, could take the whole ruling and sort of nationalize it, make a sort of constitutional finding of fact for under federal law that he did this, and therefore all 50 states have to remove him. So it would just be this pattern where Colorado is singular and other states, maybe jump into the fray and do the same. But it's a very chaotic situation. One of the dissenting justices pointed to this, where he's on in some and not others. Okay, so that's one thing the Supreme Court, could do, to just affirm or pass on it. I think it's more likely they reverse, don't shoot the messenger. But it's not going to be in these big cases. You really look for the court. Like Nixon versus U.S. It would be the big analogy. The court's unanimous. So hard to see the court being unanimous here. And in fact, they'll probably be bitterly divided. That'll be bad for the Supreme Court, kind of whichever way it comes out. And, it will create sort of ill feelings on both sides. All right. But let's say they want to reverse. What can they do? They could take a page from the district court ruling and say, you know what, he's not an officer. That would be easy and very cabined. It would really be saying nothing about other provisions of the Constitution. It would have, it would draw strong dissent, but whatever they do probably would. So there's that. It could say that I don't see they're saying that, there wasn't enough factual basis for the district court to find he engaged in insurrection. That's really the business of state procedure and a trial court. But they could say that the construction of insurrection is just too loosey-goosey for federal law. That is, as a matter of federal law, insurrection doesn't fit the definition that the Colorado Supreme Court applied. Therefore, it's an error. Therefore, reverse. Those are the main two, but on the merits. But then there's one really big sort of cluster. It's what really all three of the dissenting justices said in one version or another. It's what the Supreme Courts of Michigan and Minnesota have said, which is basically, this isn't for a state Supreme Court to do. It's, and the justices on the Colorado Supreme Court, one said, you can't construe our election code that way. It's not built for that. Another said, even though it's a command, you need more procedural due process to implement it. And that means you need, say, a conviction from a court on insurrection, not just a conclusion on the preponderance evidence by a district court. And one said, basically, this just isn't right kind of thing for a court. Really, it should be Congress that does it. That cluster of dissents that basically, it's not our job, guys, to put it in blunt terms. It's somebody else's, but it ain't ours, is very much where you could see the Supreme Court ending up here. They've done it before as, part of the Roberts' supposed, modesty of not interfering too much. Whole nother topic. What that amounts to, but basically, the argument would be we can't really do this. But there's a wrinkle if that's the tack they want to take the U.S. Supreme Court, because Colorado, 3 justices did say that, but they said it as a matter of Colorado state law. The Supreme Court would have to be saying it as a matter of federal law, and it's not enough, as I see it, for them to say, we, U.S. Supreme Court, just think this isn't for us to decide, it's really for Congress. They said something very much like that in the gerrymandering cases, where it's just not enough judicially manageable standards for us to wade into the fray here, and therefore we won't. The problem with that is Colorado did, and Colorado did based on state law. So the Supreme Court, I think, will have to go a step further and say there's something about Colorado's having decided to do it that violates the federal Constitution. So it's not enough for them to say, under our own rules of what we take and what we don't, this is something that we have to leave to Congress. They've got to say that the Colorado Supreme Court violated the Constitution, committed federal constitutional error in deciding it for themselves. So that has to be something like either saying that you look at the text and the Supreme Court would add to its structure and history, and they would say it's for Congress to decide. That's the actual, integral holding of the provision itself. So it's not that we're staying our hand. It's not that you need the criminal conviction, as one justice said below. It's that as a matter of federal constitutional law, only Congress can decide this, and therefore Colorado and all the other 50 states are out of luck and out of business in trying to disqualify him. All that can happen is in Congress, and there's not enough time for that, by the way, and it wouldn't happen anyway in the House of Representatives. And so, that would be probably the end of the road. And all of this is sort of off-road, as I'm suggesting, but the end of the road for the whole challenge under 14th Amendment, Section 3. So but what's important is they need to find that the Colorado Supreme Court violated the federal Constitution in taking it upon themselves. And that must mean some implicit command that they can't, that it has to be for the federal government and presumably for Congress. And that is a bolder and more far-reaching holding, in contrast with, say, the president isn't an officer, which is an easy kind of one-way use ticket for getting out of this mess. Anyway, that's what the next 15 days hold: total bedlam and crazy arguments, etc. And any way they go has some complications. I think the betting odds, don't shoot the messenger, is the Supreme Court doesn't let it stand. If it does, we've got this whole crazy quilt issue of being on the ballot in some states and not in others. How would the court deal with that? But there will certainly be substantial thinking on the court that this is just wrong for courts, even the Colorado Supreme Court. And that may well be the focus of the oral arguments that are coming and soon in the U.S. Supreme Court, unless the very improbable happens and they just say, no, we don't care. Colorado's made its holding, but we're not going to weigh in, which I and most people don't see happening. So stay tuned. Very, very interesting constitutional moment. Very, very important political moment. And they converge in the next 15 days. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.